Keep this short, sweet, and to the point. The reason I brought up the 2010 when I went to court and they had charged me was because on one charge was the burglary charge was 500,000. The gross sexual imposition charge was $250,000. No 10% cash bond. After I won the case, they turn around and they changed the bond because the prosecutor had to pay the bond once they lost the case. They had to pay the bond. So instead of paying the whole what they were owed on a $750,000 bond, they knocked $250,000 off of it. My evidence to prove that is the court index newspaper list. Um, it lists your bond amount and what you were going to court for. So there's the evidence to do. That's for the FBI, because y'all always watching me. U.S. Marshal Service, Homeland Security, or whatever, and the Provost Marshal. Absolutely, the Provost Marshal. Now let's unpack what we're dealing with here. Now, Jag Properties is they're an agent of ROI Enterprises or Properties and RMB Blue Rock LLC. Now, I gave these people lawful notice because I had a dispute with them. So I gave them lawful notice. I served them this writ of quo warranto, as far as their authority to continue to charge me fiat, private commercial paper, Federal Reserve notes. Because I tried to pay my rent using the 1099, but they wouldn't accept that. They said, you still didn't pay. And none of this is money. And the court has already ruled, the U.S. Supreme Court has already ruled that you can't call yourself government if you're dealing in private commercial paper, and Federal Reserve notes are private commercial paper. They're acting in violation of the Clearfield Doctrine. That's exactly what this judge did. Her name is, our magistrate, a magician. Her name is Jacqueline Purcell, Purcell. Now, what she actually did, let me get to this first. I gave these people lawful notice, okay? These are the names here. That's the names here. That's everything the suit says. This is all founded and well grounded in law. They did not answer. Okay, I served them a writ of quo warranto, requesting their authority to decide an issue on a Moorish American national. I'm not a U.S. citizen. I'm a national. We've already established that. And I have diplomatic status. Now, so what I did was, as part of my birthright, I made claim to some land. And it just so happened that the land I claimed my apartment happened to sit on the lot that these buildings are on. This lot is mine now. As the Moore Science Temple has filed a certificate of title for this property, which they cannot have. A deed is not a title to the land. That's a colorable title. But they were given lawful process. They defaulted because they refused to answer this suit that was filed in the consular court. The Moorish nation has a treaty with the United States. That's why you have this right here, the eagle with the 13 olive leaves 13 olive leaves and the 13 arrows. You see that fez over the head of the eagle. And then you see the pyramid. Same thing that's on the dollar. So, and this handshake represents the coming together of the friendship treaty. It represents the friendship treaty and the constitution that preceded it. Okay? So we clear on that. And the land here is Morocco. America is a continent, not a country. So now that we got that out the way, let's go on back down here and finish this out. Now I gave them lawful process. They defaulted. Now what I'm getting ready to quote here, these are maxims of law. Fraud eviscerates the most solemn of contracts, documents, and even judgments. United States versus Throckmorton. That's a U.S. Supreme Court case. Here's maxims of law. In commerce, for a matter to be resolved, it must be expressed. Hebrew, for this, the Bible is public law. We're dealing with common law here. The Bible is common law. In commerce, truth is sovereign. Truth is expressed in the form of an affidavit. An unrebutted affidavit stands as truth in commerce. These are all legal maxims. An unrebutted affidavit becomes the judgment in commerce. Now, based on this, let me get this document here. We're going to unpack this. Because these people operating in fraud and in criminals, and they are being publicly exposed because they're acting in a state of treason. Now, you see I did all that right there. Now, let's go over here. You'll see here, that's filed with the Secretary of State. What is his name? Frank LaRose. You see, I did all my paperwork. All of this was in order before they went and they filed this nonsense in an eviction court. Okay? So they were given all their lawful rights in a court of law, and they refused to participate. Now here is the actual UCC1 financing statement that was filed on JAG Properties and ROI Enterprises. All this was filed on them. Okay? So this was filed with the Secretary of State. By law, anytime a document is filed with the Secretary of State, it's considered a perfected security interest. Okay? That is by law, by their own laws. And then this corrupt judge, hold on here, this corrupt judge, she come back and let's go back here. Let me pull this document up. Let me pull this other document up here. Hold on. Now she issued a ruling that I don't even know about, that I've never even gotten a copy of. But what I did was, okay, now let's go to where they filed for an eviction, illegal eviction. Because let's go here. Hold on, let's go back here. And let's see what the law says. Well, let me point out the law on right here. This is what the Peace and Friendship Treaty states. Article 20. If a citizen of the United States or any person under their protection shall have any dispute with each other, the consul shall decide between the parties. And whenever the consul shall require any aid or assistance from our government to enforce his decisions, it shall be immediately granted to him. Okay, now, with respect to land, our rights to inherit land. Here we go, our Article 23, under the Peace and Friendship Treaty, the consul of the United States of America shall reside in any seaport of our dominion that they think proper. They shall be respected and enjoy all the privileges which consuls of any other nation shall enjoy. And if any of the citizens of the United States shall contract any debts or engagements, the consul shall not be in any manner accountable for them unless he has given a promise in writing for repayment or fulfilling thereof, without which promise in writing no application to him for any redress shall be made. The city of Cincinnati, municipal court is acting in violation of treaty provisions. This is clearly an overt act of treason. Okay? So that's for the ears of city council, the mayor, because all of y'all responsible for that judge's decision. Because you know how you're responsible for that judge's decision? Let's go back to this document here. Because I have a $5 million, I have a $5 billion. It's either $5 or $7 billion, somewhere in that neighborhood, lien against the courthouse. So you guys getting ready to be out of business because I'm getting ready to lien your EIN number and your Dun & Bradstreet number. And you ain't gonna do no business until you pay me my $5 billion. That's how that's going. Now let's go back to, okay, not that one. Okay, what am I looking for? Oh, about emails. Oh, come on. Okay, that's on the second. I need to go back before then. Okay, but right. All right, well, computer acting stupid. So let me pull these documents out here. Okay, here we go. Here we go. I got default judgment. Let's go on back over here. Okay, default judgment. Here we go. These are the parties, and this is the default judgment. Okay? Yeah. This is the memorandum I said on December 18th. This is to the Hamilton County Common Pleas Court. Hold on, let me make sure I got all that in order. Okay. Yeah. Yep. These are the parties. That's the title of the document. And this is the default judgment issued against the court. It says, once jurisdiction is challenged, the court cannot proceed where it clearly appears that the court lacks jurisdiction. The court has no authority to reach the merits, but rather should dismiss the action. This is what they were required to do. They didn't do this. On December 18th, 2024, you were served either directly or by and through your agent with the affidavit of fact, writ of quo warranto, which was entered into the record of this de facto case, and you were given 3 days from the date to that date to answer and produce evidence of your alleged jurisdiction and Article 3 judicial authorization, amongst a list of other things for the record. You have failed to answer. You have failed to answer and evidence. Well, yeah, they failed to answer and produce evidence. That's a typo. And produce evidence within the 3 days, which constitutes default and serves as conclusive evidence of your admission by silence or acquiescence to the statement of facts and redress listed in the affidavit of fact, writ of quo warranto, filed on December 18, 1440, Moorish calendar year 2024, Christian calendar year, and your lack of jurisdiction and fraud. Now, it was ordered from this court, the consular